Good morning. Hope you guys all had a great weekend. Yes. Alright.
Password star.
Uh,
Star.
Do you mind, lady? See if she starts talking again. Okay, I think she's gonna be quiet.
She was on the front half of this last week.
Okay, so I have your discussion post. Well, I kind of have it. So what I did was I took the rubric that was on the top and took the thesis and all that. And I was trying to conserve paper, so I put 3 of them on one, right? Because I was grading. But I didn't think about the fact that I was gonna have to cut them, right? So I gotta cut it off, and I gotta enter it real quick into Canvas. All right. So when we take a break, I'm gonna run and grab some scissors, slice it up real quick, and enter it, and then I'll get back to you. How about that? But I want to talk to you about them too. Okay. All right. So. Trying to find my password here. I'm like, I was just on this morning. How can I forget the password? Okay. All right. So today, what we're gonna do is we're gonna do 2 things. We are going to do our case introduction, and then we're gonna talk about the complaints. Let me pull this up real quick. 153. Okay, who can I beg a favor from in terms of going downstairs to the copy machine and grabbing some documents? Will you please? Thank you so much. You know where the copy machine is? As soon as you go down the stairs, if you're going out the library, that way, there's a copy machine up over here. Okay. Aren't those great directions? This way and then that way.
At least you don't use your lips pointing where you
Get here.
You want to tell her I had a question about question number 15 on the quiz.
That's the last one.
The last question.
What did you think of this quiz or something?
Yeah, so this quiz was blank.
It's always gonna do that. It's always gonna give you a 0 or something because it's a manual grade. So just know that it's a free grade.
That's messed up. Don't ask our opinion then.
Yeah. Alright. Huh, where did I send it to? Hey, good morning. All right, got your mark in, sir. Excuse me. Pick up. All right, awesome, thank you. What do you want? Oh, yeah, I'll take this. Yeah, that was strategic. Was it, do you think it was done?
I have no idea. It wasn't making any more noise.
It wasn't? Okay, we'll see.
Oh, if it's not, I'll come back down.
I think we might need some more. But this will at least get us into our break though.
Well, yeah, let me go.
Yeah,
I'll run
okay.
back down.
Yeah, because the PowerPoint. Okay. Yeah. Okay, so I have some documents for you this morning, and the machine I guess was out of Staples. And me and that machine are unfamiliar with each other. We're just starting to get acquainted, so I didn't know how to refill it. I don't think it was comfortable letting me touch it. And so your documents this morning are going to stay there. Okay. So, but they are pretty much in order, though. Okay. So what I'm going to hand to you are the general facts for our case number 1. It looks like those are pretty much together. Okay, that looks good. Okay, that looks good. Okay, this isn't going to be as hard as I thought it was. Okay, so it's just not stapled. There you go. But rather than pass it around, I'm just going to walk around and get it. I think that'd be easier, okay? Right now, yeah. Let's make sure. 1, 2, yeah.
Sorry, I'm making it complicated. Ignore me.
What did I do? Hold on, it did something weird.
They look like they, when I pulled them off, they looked funky.
It looks a little
But I
funky.
didn't know what you were planning,
1,
so.
2. Where's the rest of it?
How many pages before?
Okay, we're missing a page.
Here, I'll run back.
Yeah, we're missing page 2. Okay, so don't worry, we'll fix it. I'll run downstairs and get a copy of page 2. So I'm gonna give this to you, but we're gonna know that I'm gonna give you page 2. Okay? So what do you have all of a copy of?
There's one at B.
I have,
Yeah.
I have 2. Is this what you?
That funky machine.
Because there's 1, 2.
It weird something, it did
Oh,
something
yeah,
very weird.
Oh, wait.
Yeah, see it's missing, see it says 1 of 3, and then 3 of 3. Yeah, it's missing 2 of 2.
Yeah.
Yeah,
Okay.
there's no.
So this is something really funky. All right, here you go. So I will go back and get you page 2. But we have enough to start with. Here you go. Oh, yes, please, thank you. All right.
I don't know why.
Okay.
Take up so much space.
Here you
I just
go.
love that you were just like, stay with me.
Here we go.
Oops.
Okay, did you, okay. All right, so let me look at the original and see what happened here. Oh, did I miss you? Okay, there you go. Okay, so, yes, we missed page 2. And then it missed the back of this one. I see. Okay, so basically we need this page and this page. We're just gonna do those together. Oh, sorry. Okay, all right. That sucks. Okay. So here are our facts for our first kid. Let me do this though first, before you get to read and get excited. Let me see here. 1, 2, 3, 4, 5. No. Let's just count by 1, 2. 1, 2.
Say one.
Sorry, 1, sorry.
That's all right. It's Monday. We'll get there.
It's Monday.
1, 2.
2. 1, 2.
Okay, awesome. So, can I have all the 1s be on this side and all the 2s be on this side? We're about to become adversarial. So, 1, 2.
Okay, hold on, I have to uncamp.
Oh, sorry about that. I should have told you not to get all set, okay?
You know what to do.
This is our morning exercise, moving around a little bit.
Hey, we need to go.
Oh, come on,
What's the
really?
last one?
Okay, so what was the last number? 2. 2, okay, Ian?
Yes,
Sir, you're gonna be 1.
okay,
Number 1,
all right,
because you are number 1.
thank you.
All right.
We're going to.
And did I leave him a document? Did you get one for him?
We already got it. He was
Okay. So Ian, what we discovered is that I was a goofball and I didn't make the copies properly.
Okay.
So during the break, I'm gonna go make the back of the pages that we're missing, okay?
Sounds great.
All right. I'll just-
Oh, God. Running up and downstairs.
All right. So, wait a minute. So who's on the side? Oh, one.
Here.
Who's on the side? Okay, how many people are here? 1, 2, 3, 4, 5, 6, 7, 8? And are we all here, do you think? Are we all here today? No, we're missing some people? Okay.
Yeah, we're missing one person.
Just on this side.
Angela, that's right, okay.
So 1, 2, 3, 4, 5, 6, 7, 8.
Oh, that's right.
Oh, gosh, that's right.
Well, I
Okay,
think
She's
1,
staying
2,
home.
3, 4, 5, 6, 7. Okay, when she comes back, she's gonna be with you guys' group, okay? So you guys remember that? Okay,
I'll just grab an extra thing.
okay, I'm gonna post it too. Okay, alright. And Beth is already posted on Canvas. Alright, so I think this will work.
Okay.
Alright, so over here, my number 1s, you all are going to represent Sarah Smith. Remember that little lady in the little accident thing, making that left-hand turn?
Yeah.
And you all are going to represent Mr. Bobby Jones. Alright? Now, so here are facts about Sarah Smith. She's a full-time TCC student, and she also works full-time. Now, she suffers from migraines, and she has a prescription medication for that. Side effects of the prescription medication does include some drowsiness, maybe some other things, but for right now, this is what we know. As she was leaving the TCC parking lot, headed to work, and she's driving a 2012 Honda Accord. That's kind of what we know right now, okay? Are we okay with that? Okay. Bobby Jones, he is an employee at FedEx. Now, he is speeding down 19th Street in a FedEx truck. He has a driving while license suspended, that's what that DWLS stands for, in the 3rd degree. And he was headed to University Place Primary School, in order to drop off lunch money for his little baby. He's being a good dad. Okay.
Really quick question.
Yeah.
Does 19th, does it run east, west, north,
So,
south?
that's part of your discovery.
Sorry.
All right. Yeah. All right. So let's keep going. So Sarah was leaving TCC parking lot and headed out of the exit that only permitted a right-handed turn. You guys know what I'm talking about?
Yeah.
That sign, the little arrow says this turn only. Now, did we do this before? Raise your hand if you ever have made that left. Nobody's watching. Here. Okay. Uh-oh, let me see if our thing stopped here. I think it did. I think it stopped because I have the internet on for some goofball reason. I'm just goofing up today, y'all. Oh, okay, but it's still recording.
Now, can I ask
So
you a
all of
question?
that's on the recording.
Was Mr. Jones' license suspended at the time of the accident? Yeah?
Yes,
Okay.
yes, okay. All right. Let's into the details. We'll talk more about that. All right. Sarah was leaving the TCC parking lot and headed out the exit that only took the right-hand turn. She was turning left. Bobby was heading down 19 while speeding. 19th Street is a 5-lane road, including a center turn lane. That's not accurate. Bobby was driving down lane 2 until he got just to the opening for the school parking lot. So just where this turn is, right? Just where that sign is. When he got over into the first lane, hitting Sarah Smith. The speed limit on this road is 30. The accident occurred on Monday, October 14, 2013. Medics were called and responded to the accident. Okay with that so far? Yep. Okay. So those are our facts, all right? Now, this is why the sequencing of our courses becomes really critical, because if we, in an ideal world, you have all taken 152, which is Intro to Civil Law. So we have a discussion right away about what sort of claims we might file. You with me? But that's okay. We're going to sort of weave that in. So if you feel a little bit overwhelmed because we're doing the procedural part as well as a substantive part, just kind of work with me, okay? We'll take it a little piece by piece, and I think you'll get it, okay? Because we're not going to make these complicated claims. All right? Are we okay with that? Okay. So now let's think about our evidence. You guys have a PowerPoint from the evidence discussion we had last week?
Yes.
You thought we were just going to leave that behind in the dust. See evidence. Woohoo! Didn't like it. It was so boring, dry. No, pull it out. We got to come back to it.
It's on your back of it.
Yeah. Oh, this one here? Oh, the evidence. Let me see. I might.
I shared it.
Let me see.
I want that.
Yes, I have extras. Who needs one?
I haven't.
I have 2 copies. Y'all are so wrong. What y'all do with my PowerPoint? Y'all was like, y'all toss my thing. Okay, who was not here? Okay, so I'll give you priority. Oh, were you also not here?
I was not here.
And she was absent that day.
It was your birthday? Oh, I'm sorry. I'm so late your birthday. All right. So everybody else got to share, okay? Because you were here, right? 20 minutes fair? Okay? All right. But if you have your iPad or your tablet or your iPhone or your whatever, it's on Canvas. Yes, ma'am. So just go to week 2 because that's where we presented that material. Okay. Gee, Hold on one second, let me get there. Evidence,
At least 30 minutes.
Is this on
it's on what?
files?
No, so go to week 2, go to modules, and go to week 2, court system, jurisdiction, SOL, and evidence. And then you should click on, let's see, I think, oh, it's PowerPoint Wednesday. And when you click on it, it'll give you the title of evidence. You okay with that? Everybody got? All right. So. That's you. All right, so we need the rest of this to really go into detail, but. Right off the bat, with respect to Bobby Jones, I said this side over here is gonna represent Bobby Jones. Right off the bat, are there any evidentiary issues on behalf of Bobby Jones that you think might be implicated by the rules of evidence that we covered last week? Are there any of those rules that you think might come into play with respect to one piece of information, at least one piece of information that you have just right at the top here? So go back, look at those rules. Now you over here, I want to ask you the same thing. Now it could be potentially okay. So I don't want you to make a definitive conclusion. But is there anything at all under the rules of evidence that you might think, can we use the rule of evidence to address something here? Or should we? Or should we anticipate this on the other side? And how might they try to get this in? So you guys think about that, and then I'm gonna run downstairs real quick and get this on the machine, okay? Are y'all okay with that? Everybody knows what you're doing? Mm-hmm. Yes. Okay, I'm right back. Don't run away.
Yeah, well, she wrote it down. So we should put this back to the
When I find it, I can use my words. Yeah. Keep just placing those.
They're gonna burn
I was going to, and I had my phone. You know, and I was like, I was
Generally, visits like that, don't have a car, just like skip marks.
and we didn't not do it until midnight, and so it was like 11:55. I got 2 quizzes to do right now. I have some sort of like, I might have like, I'm trying to sleep. I'm like, good for you.
Wait.
I didn't, yeah, I didn't do this. They're different.
They're gonna bring out the medication. Yeah, ours is at Omaha or Rome.
Okay. So here's page 2 or 3, and then this is the very last page, okay? All right, so I'm gonna pass that around. And then this is the very last page, okay? And then 2 of 3 is heavy.
Just that one?
So you have page 2 of 2 right there, and the very last page is over here, so you guys will circle it, okay?
Just keep it one page. Yeah, they're bringing Alice around. So I think it's.
Y'all don't
Oh, they have the other one.
We're supposed to have rubric, right?
There's more underneath of this, there's more.
Yes, so 2 of 2, so 2 of 2 is coming, and then this is the very last page. So the last page is coming.
I think it's.
You might have just had a couple of attached, but yes, just take that. There you go. Take that.
No.
What do you want to do? Rubric's coming.
Yeah, but you're not looking at rules of evidence, you're going back and you're looking at the information that I gave you last week. And what you're doing is you're saying, for our client, is there anything here potentially at issue under these rules?
Okay.
There's something here at issue for your client, I'm telling you right now.
Yeah.
There's something at issue. I'm not saying that it's gonna come in,
We don't know.
I don't know.
Okay.
But you gotta be able to look at these stats and think, wait a minute. The rules of evidence, there's something here, okay?
Andre, I have
Oh, awesome, thank you.
Yeah.
Not necessarily.
Here.
I may have had those things that impact, say, report. You have no idea what I'm talking about. I got an ambulance and stuff.
Subscribe.
Insurance, like,
You should have more.
The rubric should be coming around.
I know, I think we ran out.
oh, this one, there's one.
Oh, never mind.
I want to say Mark was 39.
Subscribe to migrate that.
Yeah, of course.
And then you just make a good picture.
There was no, nothing audit, so actually,
Okay, are y'all okay right here?
yeah.
Yeah? Okay, thank you.
No, it didn't say that she was taking it. Yeah. I think that's the only thing.
All right, so in addition to that, this group over here, once you do your client, then I want you to look at witnesses the information under items 1 and 2. All right, on the making connections, 1 and 2. Over here, I want you to look at 3 and 4 in addition to your client, okay? 3 and 4.
Can I ask you, does the question mark after drowsiness have to be? A question mark?
We're doing 3 and 4. The causes maybe.
Maybe, okay. I know what I'm looking for in my Did you read it?
Yeah. Exactly. Start this question. Yeah. Yeah. What's it called?
Yeah.
Yeah.
Okay.
Oh, here it is. It's on 12.
Oh.
The background of our quitters.
I don't think it matters.
Yeah, it does.
Yeah.
Yeah,
should have
confusing, yeah,
answered
he
right
did.
at the moment.
I read it, it's just where it was. Background check.
Yeah.
Yeah, it's,
How is it?
it's just a waste of time.
I bet.
Okay, 9:04. I'm gonna give you about 10 more minutes, okay? 10 minutes.
Under 403.
So you guys have 1 and 2. You're applying at 1 and 2. You're applying at 3 and 4. All right?
Yeah. Yeah. Yeah, that's correct. Yeah, that's correct. Yeah. Yeah.
In other words, the statement is really.
Can you hear us stuff on here? Okay. Yeah. Excited.
I did somebody on right check.
It's 403 to 403.
I don't know why it's fine. I just overskimmed it. Oh, that's awesome.
Yeah.
Just to get, like, just to have a person knowledge, introduce it.
Yeah, it does say you were right. Yeah. It's in the FedEx truck. It's in the FedEx truck. It's in the, yeah. And see, I told you it was in the truck. I told you it was in the truck.
Okay. Oh, I'm like, I still read the first one, went to the third one, and I went to the fourth one.
Yeah.
Okay, so
In the FedEx truck, yeah. Especially that he's been driving.
Someone else, so, but.
In third degree, that means he's had 2 other charges.
Some schools or some of the training has.
Yeah. And he's using it for personal business. They're all, yeah, big mess. Yeah, that's true. He's driving like a police car, or mom.
Right, they're gonna say, well, some reason that's.
Yeah, on the table.
Yes, she was having to leave later.
Really?
Yeah, the next page.
Yeah.
Which one did you,
Big
where did you
Yeah.
find that?
Number 5.
Yeah.
I feel like they
Turn into the,
Right here?
no, turn into
the first one.
My
No
sister
matter what,
was
they give it a go.
Yeah.
Oh.
So they should turn Jessica Baker.
Yeah.
We're gonna send that to her. But it's just
Right.
Jessica Baker?
Jessica Baker, everything
Yeah,
that
she
she
was.
says is so, if they were gonna say no, it's presence of depression. And, what's it called, excited about it. Because she's.
Well, yeah, but she doesn't seem to be excited.
Are you kidding? Miss Baker is saying, oh, that Miss Smith, it was screaming, he came out of nowhere.
Yeah, Miss Smith was, right? Miss Baker.
Miss Baker has had the.
Which is why
Yeah.
I discovered it was not an excited, so we should say Miss Baker, or that Miss Smith was excited about it.
Yeah, Miss Smith was, but Miss Baker, that is the correct one.
I made for us,
Yes.
it's just hearsay. The thing like they go in, I go down. Kind of thing, they were like, yeah, you may want to quit, but
But it's still because you're
in
amended again.
Sorry.
DWL.
They're good guys, though, and we don't need to, it's irrelevant.
I know,
It's
but
unfair.
They didn't like it,
it's good rule. It's good rule.
Sorry.
I was looking for it, and I must have just overlooked it. I just don't know.
Say that they were
And then the hearsay, they don't.
Next winter.
Yeah, yeah.
I feel like I'm missing something, you know, but I don't know.
Your brain's like today.
I am missing my brain.
I know.
I'm not gonna tell you all put together today.
That's very good.
Give me a couple more days and then I'll be.
Oh, yeah, well, yeah. Get into it.
I would love to.
Giant ball.
Unless you come in.
What? Like, where you watching? In 30 Greenland.
Oh.
Yeah, I got to go off. But,
It was fun. Then I get dropped. I was like, you know what, I leave my car. We have none of the webinars indicate the following information.
Yeah.
Page 3 of 3.
Sorry, on the deck.
Come last year. Yeah, I take it regularly. Or daily, or at least once. Right, but then I'll hear in, the paragraph in number 6, she says, oh, I didn't take it this morning.
And he was in university, but he's trying to get to his son's school. So that's private business company. Yeah.
While he's like.
So you guys know she might have been negligent, she did not take her medication. Or was she negligent, or was she negligent, or she takes her medication, she could have been like so.
Maybe he didn't let them know.
Oh, of course not, yeah.
Yeah, because I've been still working. Yeah.
They wouldn't know.
No, I mean, she was doing it in every.
Yeah,
I think he got
Like,
like,
y'all just go for it, y'all.
It was a late night. Always.
I need,
But I see what I'm saying.
I see what you're saying, but that's what they've been saying.
I need to map it out.
And short times, and no more scared than she was.
Yeah, no, I know.
oh,
That's what I would try to do, is she lied about it. Just don't be taking this, and just don't be too toxic. They'll check your AC. Most of the time,
drive
I
over, I
would
have a duty to.
raise you, just like when you leave work.
Yeah.
Duty of care, I don't
You don't care, where you just. Toxic vibe.
Duty of care. See, I'm halfway there.
I got hooked on those.
I need to see the nice. So lackluster.
Oh my. Yes.
No, it's really
I know,
hard.
I stopped drinking them and I was sick for like days later, 'cause I guess it was coming out of my body. I don't do it again. Yeah. They were good. They don't give me jitters. It's so expensive, the ones that don't have sugar.
Actually, you guys, do we really like to,
I don't,
we don't wanna get rid of
use it.
We don't wanna get rid of all of them.
I wouldn't get rid of it.
What we wanna
Oh,
get
yeah?
rid of is Stephen, and she heard
The
Mrs.
Red
Sexton
Bull.
came
You know,
out
that's
of
the last time I
nowhere.
drank Red
We
Bull in
want the
Vegas.
rest of it, where they just.
But two shots last night.
Because that proves that she was on, you know, she didn't look, and she also didn't look at something else.
And then whatever
So,
he did,
so the argument that she's a
Yeah.
by her saying things came out of nowhere.
Yeah.
Obviously, it did come out of nowhere. She's just high as a kite. So I think we can use it, I wouldn't get rid of it,
Okay. But we have fun.
you know, because then this lady, she, what I want to find is that we were like, because Andrea gave us a clue. You know, she said, there's something we want to talk about, there's something we want to discuss. And I think that it is the DW. So I think maybe that's what we
You know where Master Farms? What the road is?
He's drunk.
It's like, you know, during the
I
off.
seriously didn't follow up on that.
Okay. Well, that's number 6. Here, here's one.
Thank
Thank
you.
you.
Oh, no, I have coffee after. I don't do that.
I'm gonna start making you carry my glasses. Okay, we ready?
Yeah.
Alright, let's do it. So, with respect to Sarah Smith,
That's it.
let's start with her. What do you think? Yeah, what might be a potential problem for our
All
client?
problems would probably be the drowsiness, the medication.
Okay, the prescription medication, right?
Yeah.
No, but not this, doesn't mean she took it, because they might try to bring up she's been prescribed that.
That's the first thing if we try to attack.
Exactly. So
Saying
what,
she was
so,
under the influence.
and what's the first threshold showing we have to make for evidence? It has to be what? What's the first, yes, that's right, exactly. The first threshold showing we have to make is that it's relevant.
And it isn't.
So before they try to bring in the fact that Ms. Smith was on this prescription medication, they have to show that it's relevant.
Yeah.
You with me?
Yeah, and there's no like police report saying that she was impaired, so I don't believe it would be relevant.
Well, I'm not so sure about that.
No,
Okay?
well, of
But,
course not.
okay, but so I just want you to think at a baseline level though about how these rules sort of apply to what we're doing, okay? So the idea is that it's relevant, okay? Then the burden shifts to whether or not there's some basis to exclude it, because the presumption is if it is relevant, then it's going to be admissible, right?
Yeah.
So then you have to show some reason as to why it might not be relevant. You with me?
Yeah.
Or why it might be more, what's the phrase?
Oh, I know.
More prejudicial
Yeah,
than
prejudicial.
probative, right?
Yeah.
And to show that the prejudicial nature of it outweighs any probative value.
Like on the prescription bottle, it says only take at night kind of thing, maybe she's been told only,
There you go.
directed only take it
True,
at night,
yeah.
so
Yeah,
why would
yes,
she
yes,
take
yeah.
it during the day?
Doctors.
Okay.
last orders.
Now on this side over here, how might you, so think about the rules of evidence and what we spoke about last week, right? What kind of person, hold on one second, what kind of person might we get to provide testimony about this issue? What kind of person? Are we bringing in a lay witness? Or might we have another type of witness that we spoke about?
An expert.
An expert, some sort of expert witness, right? Some sort of doctor who's going to talk about that prescription medication, assuming that it's something that she took, or even if she took it maybe like the day before or earlier that morning, maybe that expert might talk about what?
How she.
Side effects.
Side effects, how long it stays in the body, what sort of effect it has upon it, mobility, and things like that, right? Are we okay with this idea?
Yep.
All right, so now let's flip it over here and come to Bobby Jones. What's something potentially, implicated over here for your client? What do you think?
He could have been drinking.
drinking. Okay, let's hold off on that. We're not gonna go, let's not
Driving
go
while
down.
license suspended.
Let's not drive our client on the bus right away. But yes, yes,
Driving
yes.
while license
Okay, so they named it for
That's
you
our whole
guys.
case, pretty much cut and dry.
All right, so let's all come together. Hold on one
We're going to
second.
number 5.
Let me get everyone's attention, okay? So we're looking at just those little facts at the very top there. And so that driving while license suspended, as they call that over here, right? So,
In a company
in a
vehicle.
book, okay, all right.
Probably not
So,
insured because of the fact that he was driving a company vehicle while his license was
so
suspended.
how are they gonna be, so what's the relevance? How can they make that relevant? And what should we say in terms of why it might happen?
They can make it relevant and say, well, he already has a driving record, you know, he shouldn't have been driving this car, whatever. And we're gonna say, well, it's inadmissible, it's unfair prejudice. We're gonna call, how's that? News Veterans 403.
So so actually give us some language. What under 403 are you going to use?
403 is,
Because here's the other thing. I think you jumped to saying that, I think you give something away when you say, oh, it might be admissible, but it's whatever. I think there might be a potential argument about, is it even relevant?
right, it's not relevant.
So you might just start with that baseline presumption before you get into all the sort of unfairly prejudicial and all that kind of stuff, right? That comes after the court finds that it's relevant. First, you got to make them show how it relates to how he's driving today. You with me?
Right.
I know some people who drive with a suspended license, right? And I try to warn them, you're gonna get pulled over, you get a warrant, depending on what city you're in, you're going to jail. But do you know some people, right? Does that necessarily mean an abandonment of it by itself, right?
Knowing that
If
he
his
has suspended
license
his
is
license.
suspended, why is he working? Isn't it fair that you know that?
Okay, I want you to keep in mind, this is your client. So you ask these questions, and you have to spin it, and you have to come to his defense.
But wouldn't it be that because he knew he had a suspended license, he was driving more carefully as to not?
Oh, okay. Very interesting.
Because he didn't have insurance.
Okay, interesting.
He
Okay.
knew that
All right,
that's his
look,
livelihood.
hold on. Now she said, or that FedEx is liable. Might you think about suing FedEx too?
I've been thinking that out the whole time because the fact is they should have been checking on their
Because they
employees.
have more
All right.
money.
Okay. All right, so you see her. So hold on. All right, so you see how these things. All right, I know you guys are really excited. I like that. But let's make sure that we're kind of having a manageable dialogue here, okay?
Yeah.
So let's go to number 1. Item number 1. I gave that to you guys, right? What's item number 1?
Present sense impression.
So for item number 1, everyone. So can I have everybody on the same page? So groups 1 and 2, same page.
Okay.
Let's wait. Everybody ready? All right. So item number 1. So they got ready, then you start talking. All right. So item number 1, we have James Bond. Look, I had to get creative. Okay?
Yeah.
Mr. Bond's name is listed in the CAD report. Do you know what a CAD report is, first of all?
No.
Do you know what a CAD report is? So when you call 911, this is a little funky looking scripted thing that they do, typing up everything. You know, officer arrived on the scene, blah, blah, blah. This has all kinds of great information in it. Often names of people they talked to on the scene or first approach that may not sometimes be in the police report.
Yeah.
Yep, so every time there's an officer arrives on the screen, there's some sort of CAD where it's not your 911 report itself, but it's that little CAD of that communication between the officer and 911. All right? So he phoned 911 to report an auto incident and that he heard a woman screaming help.
That's what we thought.
Presence of
But it's,
emotion.
who knows who the woman was? It could have been this
Yeah.
Ross.
Exactly. So depending upon who this person is, whatever, right? We have to lay some foundation, right? Was she screaming help because she was at the scene?
Yeah,
At that
exactly.
particular, and sort of looking at that and seeing that? Okay. We okay with that idea?
Yeah.
All right. Number 2, Tia Frost witness. So Miss Frost's name is listed in the accident report. Miss Frost was emotionally upset when officers arrived to the scene. She had been walking and she observed the entire accident or incident. Officers had asked her to be seated in the back of a patrol car while they assisted others, directed traffic, and gathered other information. About 30 minutes later, when Miss Frost was calmer, officers spoke to Miss Frost and took a statement. What do you think about this?
It would have been excited,
Excited
except it was 30
Yeah.
minutes later.
Oh,
Yeah.
oh, you guys are
Excited
good.
utterance,
So you guys okay with that?
Yeah.
Awesome, awesome. So,
I think the more, present sense of impression, it's not excited utterance.
no, what they're saying is that,
However, it's labeled.
Okay, right.
all right. So now here's the thing. The reason why it's not present sense is because had the officers came to her, right, and well, had she been talking about what she was experiencing at the time, right, then that would have constituted present sense impression. She's not excited. She's not under the emotional impact of the incident, right? She's just speaking out what happened at the time, okay? However, in this instance, what they're saying is that, well, if it had not been so much later on, right? So can you, because it says initially she was very upset, right? So had they spoken to her in the moment that she was upset and all that kind of stuff was going on or whatever, right? Just, then that might have been excited utterance. But look, they took a whole bunch of time. They sat in the back of a patrol car here. Don't worry, have a seat right here. They went, they spoke to people. They directed traffic.
She might have
And then, you know, she might have took a Xanax by that time. You know, she's I'm just saying.
No wonder she's gone.
Okay.
Yeah.
All right. So remember, there's no necessarily right or wrong, but I want you to just think through the analysis, okay, in terms of how it might or might not apply. All right. This is good job. Good job. All right. So over here, you have number 3.
Yes.
Mr. Rick Martinez. Can I get a reader over here for Mr. Martinez? All right. Thank you, Ashley.
Ms. Martinez was approaching the entrance of TCC where Miss Smith was getting ready to exit. They had come to an abrupt halt and Miss Smith seemed to not notice him before pulling out into the exit. He told the officers that he felt a little uncomfortable because he had mouthed a negative word to Miss Smith for not allowing him to cross her. He says that he continued walking for a few seconds before he heard the crash. He told the officers that Miss Smith was definitely at fault. Preliminary background check indicates that Ms. Martinez has a 2007 theft in 3rd degree judgment known as OD.
All right. So let's talk about this a little bit.
Oh,
Because he
yeah.
heard it.
Okay.
Yeah.
So what are we getting at with this one?
And how would he know it's definitely?
Okay, hold on. This is not your question.
Yeah, I
All
know.
right.
Yeah.
All right. So what are we getting at over here?
Okay.
What are some evidentiary provisions that might be?
He mouthed a negative word, which means he was emotionally charged. And he noted that she didn't see him, but he didn't see the accident.
That's right. So what are we getting at? He didn't see it. He heard something.
He heard something.
So what he heard could be what type of evidence? Yes, ma'am. That's exactly where we're going. But everything else is probably going to be more so what? Circumstantial. So is he going to be able to offer any testimony as to like who is at fault?
No.
Probably not. Can he talk about, however, that she almost kind of cut him off?
Yeah, and that she didn't seem to notice him. This seems to be important.
Okay. All right. Are we all right with that? Okay. Now let's take the second piece of that. That theft thing that he has. Anybody know what that OD means? That OD.
No idea.
All right. So when we look at a person's criminal history, we have a couple of different options, okay? The best option is there is no history,
Yeah.
okay? All right? But sometimes, you know, we have some moments of where we lapse or we have poor judgment, right? So sometimes we have some experiences. All right, so when you look at the thing, our JIS, we got all these different categories up here, and then there's a J category. This is judgment. So the G is gonna be for what? Guilty, okay? This person, either they pled guilty or they went to trial and they were found guilty. You with me? You okay with that? Okay. Not guilty. They went to trial, they were found not guilty. Is that right? Then we can have, let's see, sometimes it'll just be open. There won't be anything. This can mean one of two things depending upon the jurisdiction. It just kind of varies depending upon how the jurisdiction does it, okay? For the most part, if you see the charge right here, right, and there's nothing, it means that it's presently pending, meaning it's probably still in the pretrial stage. Are we okay with that? So we're still having some hearings, we haven't gone to trial, we haven't pled just yet, all right? In some jurisdictions, however, you can have what's referred to as a deferred sentence, or OD. And what this means is the person has entered into some sort of agreement with the prosecutor in the court, whereby if they meet certain terms or conditions, maybe pay a fine, community service hours, some treatment, you with me? This depends upon what the facts are, right? Then at the end of that time period, if they comply with all the conditions, either the court's going to dismiss it, best case scenario, or it'll be reduced to a lower charge, or perhaps even an infraction. We okay with that idea? Okay. Now some courts will actually it'll appear as DS deferred sentence, or it'll say OD, other disposition. Or some jurisdictions will just leave it open like this, and they won't put anything. You with me? All right, so what we have here for Mr. Martinez is we have this. We have an other disposition, okay? So now what do we know about, what do we know about our evidentiary rules in terms of crimes of dishonesty? What did we learn last week? Are you okay, sir?
Oh, I'm fine.
Okay.
I'm just good.
Are y'all okay? Y'all look so down
It's
over
an
here.
off day.
It is.
Off day.
So what do we know about crimes of dishonesty? We spoke about a particular rule where it relates to, not character, but it allows us to, if they have a certain type of crime, then we can use it for purposes of impeachment. I'm not saying it's going to work here, but this is the, what is it? Okay, and what rule is it? E609, E609, right? That's where we can do we can look at a person's criminal history relates to a crime of dishonesty, and it's been within 10 years, right? So now they might try to, so do you want to use Mr. Martinez as a witness?
No.
No, do you?
Do we?
Yeah, who do you represent? Who do you guys represent?
Yes.
You represent who?
Mr. Jones.
Mr. Jones. Is Mr. Martinez a good witness for you?
Yes.
I think he helped you. So do you want to use him?
Yes.
Yes. Can we put him on the stand? Is this going to be an issue for us?
No.
No. Why is it not going to be an issue for us?
Because it has to be, was it criminal?
Yes.
Yeah.
Like, he has to spend-
Conviction.
Yep.
Has been conviction. We're going to argue probably that this is not a conviction.
Exactly.
It's not a G. There's no judgment and sentence. This is still pending.
Maybe.
It's other you with me? Now you on the other hand might try to argue that it is.
Yeah.
You might try to say, well, in this instance, well, hey, it's basically a submittal. He's saying on the record, I did it.
Yeah.
It's just the court's giving him a break.
Yeah.
They're probably going to win over here,
Of course.
but
But at least-
nonetheless,
yeah, but at
you
least
just
we're
want to
raising it.
know that you're raising
Yeah.
the issue and where it might potentially go. Okay?
And that potentially could sway jury.
Okay. Are we all right with that? Yep. All right. Now you had also number 4. Jessica Baker. So Miss Baker is associated with a nursing program at TCC and was leaving campus at the time of the incident. She was about 3 cars behind Mrs. Smith. She ran from her car to the intersection upon seeing the accident. She attempted to help Miss Smith calm while 911 was called. Miss Baker gave a statement to officers that she heard Miss Smith screaming, "He came out of nowhere." Miss Baker attempted to calm Miss Smith down. She also indicated to police that she saw a prescription pill bottle on the passenger seat in Miss Smith's vehicle. She described Miss Smith as seeming dazed, incoherent, a bit slurred in speech, not sure whether there's spacing like that there, but without any visible head injury. She also indicated she thought her pupils had been dilated. Do we like this witness?
Yes.
Yeah.
And we like her, right?
I do like that.
And so now if we
I can argue that she.
Hold on, pump your brakes. Now over here, what do you imagine we're gonna do to be able to get this witness to testify? You guys are not with me now. Y'all have to wait, because you're gonna need this information too. Okay, so hold on.
Okay.
So thinking about those rules of evidence, right? What do you think we're gonna have to do? What's that phrase we're gonna have to do in terms of being able to get her to talk about why it's appropriate for her to be able to give this description, these medical descriptions?
We need to know how she's associated with the nursing program.
That's right. So what is that phrase called? We're gonna like we're building a house. We're building a
Foundation.
the foundation, laying the foundation, right? And we're gonna lay the foundation by talking about her education, her training as a nurse, right?
Mhm.
If she's had the occasion to, do triage of patients who have been involved in an accident and so forth. If she's familiar with this prescription medication, if she's aware of the potential side effects, if the side effects that she's aware of is consistent with what she observed on Miss Smith,
If
right?
she's in any way qualified to say that she has dilated pupils.
Exactly. Are we okay with that?
Yeah.
All right. Okay over here? Okay.
We're gonna say that not only she has but she's also expert.
All right. So that was just an exercise to kind of help us bridge these pieces of evidence. All right. Now we're going to. So now we're going to switch gears a little bit, and we're going to talk about the idea of the complaint. All of the information that's in this exercise, so I want you to keep this, because this is going to be information that's going to be helpful to you in terms of establishing the background that you need to determine whether or not you have sufficient facts to file a claim, to file your cause of action. All right? On both sides, what type of cause of action do you think we're looking at? I know some of us haven't taken intro to civil law, but what do you think? Negligence. We're probably looking at negligence on both sides, right? So part of what you need to do then is research what negligence means. So put that down. That's something that we need to find out. In Washington State, for a tort claim of negligence, what do we have to prove?
Duty.
Okay. Let me bring support here. All right, so what are we going to call these pieces of under here that we have to prove? What are the elements? That's right. Elements of negligence. All right. So I heard someone say duty. Now, what? And let's flush this out. What do we mean when we say duty?
That person had a duty.
That's right.
Care.
That somebody had a duty of care to another person, right? Someone had some sort of duty to another.
Mm-hmm.
Had some sort of obligation that they were supposed to honor. That's never done.
Well, that's what's going on.
Okay, but remember, we're in the civil world. We're not in the criminal.
All right.
Okay. Are we okay with that?
Yes.
All right. Now, of course, we can look at this fact pattern and see potentially how this might implicate a criminal cause, issue too. But for right now, even though I love criminal law, we got to be on the civil side. Okay. All right. So, duty of care. All right. What's the second element?
Breach of duty.
Breach of that duty.
Mm-hmm.
Now, remember when we said the language is really important and the punctuation is really important, right? So do we have to prove both of these things?
Yeah, so it's
Yes.
like
Yes.
colon.
That's right. So we got to prove duty, that somebody owed someone a duty, and the person who owed the duty, they breached that duty. What do we mean when we say they breached that duty? They did not do what they were supposed to do. Any negligence laws? Okay. Okay. All right, so someone breached that duty. They failed to do what they were supposed to do. They failed to exercise the standard of care that they were required to do.
Mm-hmm.
Are we okay with that?
Yes.
All right. And then what's the third element we have to show?
Proximate cause.
Huh?
Proximate cause.
Proximate cause. Now, what is this proximate? Now, this is a funny thing. Well, come on. I I established that they had a duty. I established that they broke their duty. They dishonored their duty. They didn't honor it. So what the heck do you mean you say proximate cause? Is that more proximate cause?
No, you
Isn't
have
that the fact that I showed they breached their duty? Bam, that's my proximate cause, right?
No, you have to prove that the breach of duty caused the incident or the damages.
Excuse me? Yes, you're right.
Oh, I was like,
Because
what?
we- Right, like,
Couldn't be
most-
me.
I'm best for each other.
So what we're saying is that there has to be
I've taken it.
there has to be a
I'm
nexus,
almost done.
right? So let's say, Courtney may mess with you, right? Okay. So let's say I'm walking into class, right? And Courtney's gonna pull a prank on me, right? And so she sees me walking by, I'm trying to be cute and dainty with little heels on, and she slips a little chair and I go, right? And I fall to the floor, okay? Now, did she have a duty?
Yeah.
Yeah, she did duty, come
Yeah.
on, right?
Yeah.
Did she breach her duty?
Yeah.
Yes, she did. Now, y'all all saw me fall. It was a very light fall, right? I had a little scrape on my knee, okay? All right? We can say that scrape on the knee is approximately caused by that. But 2 days later, I come into the classroom like this, in a neck brace, and I'm still there.
Yeah.
Proximate cause? We're gonna have some questions
Yeah.
about proximate cause. You with me?
Yeah.
So we have to show there actually is a nexus between this right here and the harm that I'm alleging, those damages on the end. Okay? So proximate cause, damages / injuries alleged. Okay? Good thing? And then I have to have these damages. What was I wrong? What am I out? Medical bills? Can I not work?
Yes.
You know. Okay. Are we working that idea? All right. So, you guys represent Ms. Smith? Do we have a potential cause of action against Bobby?
Yes.
What? What's our basis?
Yeah.
I don't know if the suspended license gets us to our cause of action for negligence.
Across the line.
So maybe his speeding, right?
Yeah.
His speeding, because maybe we can say that, look, hey, even if I was making a left-hand turn, right, I could have made that safely if this clown had been going 65 and a 30,
Yeah.
right?
Yeah.
Okay. Over here.
I think your thing stopped.
Is that?
I don't know, you got a thing.
I got a thing.
You got a
Oh,
thing.
it says I'm not plugged up.
No, you are plugged up. I didn't kick it this time.
Messing that thing up.
Okay, I think we're good.
Really?
I think so. All right. So over here, cause of action, we can do the same thing.
Yep.
Okay? Now the question is going to be whether or not we might be able to implicate these employers in some way. With me? All right. So with that in mind, should we take a break before we
Yeah.
talk about the complaint?
Yeah.
Okay, let's do that, because y'all look like y'all need a breather.
Yeah.
About 5 minutes, and while you guys are doing that, I'm gonna walk around and give you your PowerPoint slides for our lecture. Absolutely.
Yes.
Moving my mom.
It was a truck. Yeah.
Okay, so again, these are not stable, but I can tell you have all the pages this time, okay?
Third degree at that. Third degree, so you have two different charges.
So, no, that he heard it is direct, right?
Yeah.
But anything you didn't directly see or hear is gonna be surrogacy.
Okay.
Yeah. And there's someone right here, right?
Oh.
Is your power back working? Is your power back working?
Yeah, there you go.
How does it work?
How long?
You've been working.
Do you have, will you go over there in that center and see if they have scissors?
What?
You got.
Oh wait, I got complaints on this. These are all on the same.
Oh, the scissors. Yeah.
Really?
Okay, there you go. Okay, so I give it
Good, good.
Oh, okay, works.
I get.
And then someone sitting here?
Yes.
Okay. Hey, can I have Yes, ma'am.
So if you ever want some, let me know, because I can't go through Friday.
And then I have 2 people right here, right?
Okay, go ahead, yeah, I'll take some. I just need to learn how to not eat them all at once.
Okay, where's Ian now? Did he get a copy?
Yeah, those little
Oh,
tea
yeah,
bags.
because otherwise if I have like everything,
Okay.
and
I thought it was so good.
and I help out at my work. You know what I mean?
Alright, there you go. Alright.
No, just so I'm curious. That's supposed to smell like sort of random. I'm like, maybe they get sick from. But then I need to figure out, because I don't have names and faces yet, but somebody thinking I was a teacher, I was like, oh. Kind of technology, so. just kind of-
Alright, thank you. Let me play Edward Scissorhands.
Oh, we also because things are here too.
Here! Awesome!
Earlier.
I need to staple my stuff.
It was not
Oh, my goodness.
I read this yesterday. I know.
You guys want staples?
Yeah, thank you.
I'm trying to go to sleep tonight.
I'll be back.
Did you give me the stapler? Oh, it's going around. I need the stapler. I think I should have priorities. I give you guys your discussion post back. Thank you so much.
I love the white chocolate. Another white chocolate, 2, 3.
The what,
6.
the pretzels, white chocolate, those, well, it's yogurt.
Yeah.
So look at your copy for me, Tiffany. Is it 1, 2? Is it back and front? 1, 2? Huh?
Yeah, no, it's 1, 2, 3, 2, 3.
Oh, my.
Are you serious?
I just
Yeah.
have,
What in the
It's
world?
1, 2, 3, 2, 3.
yeah, you just gave us an extra page.
Oh, but you have all the
Oh,
pages.
yeah.
Okay, good. All right, let's not.
2 and 3.
Yeah.
So I guess I'm gonna know 2 and 3 really well.
Okay.
and then still do it.
I don't know what it is about this morning. It is just a little off. But you know, we're making it though, right? We gotta roll with the punches. All right, let me see here. 1, 2.
Yep.
I'm not in the mood for, no, it's good normally, but I'm just not in the mood for nuts.
Oh, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Oh, I see.
That's
Okay.
funny.
All right. It just got an
Okay,
extra.
we're gonna have to definitely
Yeah.
hang out more, 'cause you're dirty birdie like
Oh,
me.
yeah.
Okay,
My
so no
mom
more
left
questions.
up
Let me do
everything.
this real quick.
This is
No questions, no questions.
No problem.
People look at you like, what's wrong with you?
I'm sorry. Can I, and if you guys don't mind, 'cause I'm trying to enter your grades, if you could please just give me a few moments.
Okay.
Thank you so much. No worries. Thank you. I just want to make sure I can give these back to you today. So.
No, I'd rather you do that.
All right.
Yeah.
Thank you. No. I get it.
Yeah. I usually say your halo is blank.
I like that.
Yeah.
And it's like, once you try that,
Oh,
like,
relax.
But I started that, I started. And my 10-year-old like, you know, heard me take a little stick off, like, mom, take a stick off. He goes,
All right, watch it.
you're not allowed to say that stuff. Thank you for bringing it to my attention. It's being removed as we speak. Don't ever say that. Okay.
And I know it's in perfection, but I'm just kind of like assuming that.
Okay, so if you're just coming in, I handed out the PowerPoint. Don't be confused, you have a duplicate of one of the pages, but otherwise, all of the pages that you need are there.
Nope.
That's exactly what
Why not?
I'm a non-pastor.
Well, and your little one's little, but your little one is still little.
These are my friends.
Anybody else want
Okay,
some
hold on,
chocolate covered
will you
espresso
hold that
beans?
list for me only because I'm in some stuff for you all here?
Still.
Thank you so much.
sorry.
No worries, thank you, okay?
Yeah.
Oh, yeah.
Must be it.
My 9-year-old's like, Mommy, you look like you're wearing a halo all the time.
You're around lawyers.
Try it.
Try it.
Pirate.
I have insane hair. It's crazy.
We know what. It's weird.
I know. I have a note-taking problem.
I'm really trying. If you're getting that headache.
Is this yours?
Yes.
Yes, that's mine. Don't take off your coffee.
But she knows I was with her. It's like 3 feet better.
Yeah.
And that's why I looked at her so proud of her. He was doing her practice. Oh, yeah, that's not.
Words, yeah.
Like retractable ones, like once it loses its like very fine tip.
But no one is right?
Like my mom.
I know, it's a problem.
Make my life easier. And I don't like the mug.
Yeah.
When you come and help me, like, you pop up in the line and go through all my stuff, and do that boxing and stuff.
Yeah.
Do not make fun of capital office supplies and supplies I have.
Oh, I know.
Because it's insane. They're all
I went to bump with the other ones.
Sir, if you don't mind giving us a few moments, please? Yeah, okay, no, please, thank you so much. I'll let you borrow, let me finish, okay?
So finally, everything. My good.
Thank you, Ian.
Of course, if she said that, it's like, gosh.
Did you ever have a chance to run into that teacher?
I did, and she tried to call you.
My husband.
Call?
Well, hold, let me
Okay,
finish
all right,
this.
all right.
Unless
We
you
can talk after
But I
class.
don't want to forget, yeah.
Some ladies buy shoes, mine depends on how they have. And stickies. Love stickies. And don't make fun of the amount of stickies all over my house. Or the fact that I write on the mirrors and drive me smarter. I'm special. It'll be awesome.
Who doesn't write on the mirror with driver's
My ex-husband said that it looks like we were thinking in my house because there's stuff written on
No, I was just saying, thank you for going that way, because I'm trying to enter some stuff for you guys.
I'm gonna have to buy some lipstick just to mess with him.
It's just dripping down.
Yeah.
People just write it if it gets really hot and steamy, you write something, and then when they get out of the shower, you don't see it when you're brushing your teeth and you're in the shower, but then when they get in the shower,
That's awesome.
I'm just letting you know.
So much fun.
Alright, one last
Get
one.
out and let it go over your little.
I know. We're
We're like, I'm so
one.
explain this to you.
Get a little bit of shaving cream so it stays there for too long.
You gonna have a sunny Halloween?
Oh, I hope so too. It's on a Friday, right?
Yeah, yeah.
That makes it so much easier.
Yeah.
Are you guys gonna dress up?
For what?
For what?
Halloween.
It's on Friday.
My daughter will be just.
Yeah, it's on Friday, so I think we're gonna be.
I don't know.
I have no idea what I'm doing.
I don't know what will it be.
Edward doesn't want to go. What 9-year-old doesn't want to go to Halloween? He wants to stay home and hand out candy.
It's simple. Yes.
I know, I'm kind of okay with it.
Yeah, I would
It's like the best idea ever.
He doesn't want to walk.
Yeah.
They know what happened.
Well, he's not even into the costumes. Like, he's so his mom's baby. But Henry's like, yeah, it's just I've got 15 costumes picked out. It's like, yeah, okay. Everybody's bad child. That they do.
The other one is fun. The other one I think is actually.
Yeah.
Alright.
I'm gonna have to make like a lot of crazy shit. Just because It's my excuse to keep myself stitching.
All right. So I want to give you a discussion post number 2 back. And I want to talk to you about these, and then we will go to talk about the complaints, all right? So Angela is not here. Angela, this Angela, yes, ma'am. Thank you so much.
No.
Tiffany, Rowan, Ashley. Tiffany, we can pass that to Ashley one more time. Thank you so much. Ebony, Ian, Molly, Krister, Kylie, Jenny. Please. We'll spell on you. That's okay. All right. Gina. Here you go. And Carolyn and. All right. So. What I want to say about discussion post this discussion post is a couple of things. As soon as this comes up, I'm going to say a couple of things.
You what?
I'm going to say a couple of things.
Wait a minute, that's too much. Y'all
No,
already
that's
having
good.
an off day. Y'all might sleep, don't go to sleep.
Okay, so while this is coming up, what I want to remind you is go back and take a look at the example that we went over in class. Okay? So because this was the first one, I gave you a model for it. Okay? So you want to make sure at the very beginning, don't repeat the facts. I know what the facts are, all right? So you want to start out with what is the thesis? What is your claim here? What are you saying the court should do? Or what is your response to the question that's being asked? Is that okay? Yep. The second thing is, when you get to the analysis, don't take it for granted that I know what the elements are for the rule, right? You can't just go into the facts. You actually have to articulate some authority for your position, okay? And then after that, you weave in the facts, all right, that relate to that, like lend support to that. Is that all right? Lastly, make sure you put the word count in. Those are easy points. All you do is put in the word count, okay? Make sure you meet it. It's very easy to get to 150, right? And then just make sure you include the word count. Make sure that you proofread and edit your document, because sometimes that can impact the clarity, of the argument. And if you did not get a grade, then it felt unfair to grade it because it was clear that there was a misunderstanding of the assignment. In which case, I want you to go back, look at this example, and if you look at, and I hope I remember to put on there the lecture where we spoke about it, but if not, it's on Wednesday, all right? And if you still have questions, then I want you to come see me. Is that okay? If you have not, so for purposes of grading though, I don't want you to be alarmed. For purposes of grading, because it still shows up on my to-do list, it's gonna show a 0, all right? And if you haven't submitted the assignment, it's also gonna show a 0. But once you do it, or once you redo it, send me an email, and then I'll review it. That'll prompt me to go back and look at it, and then I'll review it, and I'll update your grade. Is that okay? Did I miss anyone? Is everybody okay with that?
I missed it a little bit real quick.
Okay, so what I'm saying is, if your paper said NG, no grade, right?
That means that I could not evaluate you based on what you gave me because it was so far off from what the instructions were. You with me? Okay? But for purposes of my to-do list, it's gonna show a 0 on your grade sheet. It's gonna reflect a 0. Either if you got a no grade or if you have not submitted the assignment yet. But what I'm saying is, if you got the no grade, go back and look at the example, all right? Come see me, look at the lecture, come see me. However, I don't care what you wanna do. You can just come see me. You don't have to go back and look at the video. That would be helpful, but it's okay, right? And then after you redo it and resubmit it, I'll review it again, and then I'll update your grade. If you have not done the assignment, I don't know what the circumstances are as to why you didn't get it again. I don't care. I'm just saying that for right now, it's gonna show a 0, but once you do it, then I'll review it and I'll give you a grade. Is that okay? So for right now, if you got an NG or if you didn't turn it in, you have a 0, but you can fix it. Is that right? Is that all right?
Can fix it if we got a low grade?
Yeah.
Can you redo it if you just simply got a low grade?
Yeah.
Well, that's okay too. That's a fair question. Okay, fine. I like that. No, that's fine.
Thank you.
Is that okay? Okay.
Yeah, it's good.
Okay, that's fine. Particularly because it's the first one. I can't say I'm gonna do it on everyone.
Oh, come on.
All right. Is that okay? So we're okay with that?
Yes.
All right. Okay. So now, okay, y'all are so unfocused. First, y'all are like looking like zombies, and then y'all start going.
And now
All right.
we just extended the energy.
So now let's talk about the complaints. Are we all right with that? Yes. Yes, ma'am.
Extra 5 points. See that right there?
Did you do it?
Mm-hmm.
Where's it at?
I uploaded
Where's
it
that?
as an attachment like it says.
Ooh, I don't see. Okay, I'll go back and look for it. Okay. Hey, but remind me. Shoot me an email.
I will.
All right.
Where's the flag going?
So it. You got it.
I read it and
Yeah,
I
like she was.
I know what I'm
Actually, I gotta applaud you. Like, she caught that. All right. So if you actually found a case, not the Clemens case, but if you found a case to support your analysis here, and you briefed it and you attached it, then you got 5 extra credit points. But you can't do it now. So you gotta read my instructions. Okay, let's talk about the complaint. All right. Let's see here.
This is like the case, the previous case.
Okay. You guys, I keep forgetting that we're in the library, so we probably have to be a little bit quieter.
Well, it was very, no, it was very.
So tempting, but no.
Oh, come on, couple more. Come on, push them on you like,
So I climbed the mountain. Oh, there you go. Oh, and whoever needs a stapler, yes, now you can have this.
Please bring it back over there, because they're gonna hunt me.
Oh, yes, the scissors. All right, so background for our complaint. Hopefully we've gathered some information and evidence from our pre-filing investigation. What you'll come to learn is that before a case is filed, we gotta do some background stuff, right? Remember that background that we spoke about? And your information that we have here, let's presume some of that is my background stuff that we pretend and got, right? So, this is gonna help us make some determinations about things like jurisdiction, things like venue, causes of action, our estimated damages, and potential defenses and responses that we might get from the other side, okay? So let's see, Miss Smith, right? Miss Smith was driving a 2012 Honda, is that what you said?
Yeah.
Now those are pretty nice cars, and that's not very old. Those, you can drive those for a while, right? I mean, those cars are like hot on the theft list, okay?
Mine just got stolen 2 months ago.
Oh, darn. Sorry to hear about that. Okay, you guys, I have to tell you this. I used to work with, not all prosecutors like this. He was a really funny guy. I loved him to death. His car got stolen, and he was driving home. He was driving me home one day. I don't know how we got on the subject, but we were talking about how hurt he felt when his car got stolen, and he was like how he was having all these dreams about the guy. No, I should not say. No, you? What do we think? Does she have any damages? Are you gonna allege any damages to the vehicle?
Yes.
Okay, are you gonna allege some medical damages?
Yes.
Yes, you are. Okay, are you gonna allege some loss of pay or income? Yeah. Okay, so how much? What's your figure that you're looking at? You are not Miss okay? Just hold it.
Oh, yeah, I'm not Miss. Sorry. I'm Mr. A lot. Jones.
So what do you think? What do you think about? Okay, well, why do we have to have an idea of the figure?
Because you gotta know where it's
Because we gotta know what court we're gonna be in, right? So are we gonna be, let's assume that it's gonna be more than $5,000. So we know right off the jump it's not gonna be in small claims court. Could it still be in district court though?
Yes.
Because what's our cap for district court?
75.
All right. So what are we thinking? Is it gonna be more than 75?
Probably not.
Probably not. Yeah, probably not, right? Right, okay, so we're gonna keep it around, let's keep it around.
$74,100.
All right.
So nice.
Okay, so now, so what court is, so we already talked about court has jurisdiction, right? So a district court, right, would have jurisdiction. So which district court? Pierce County, because we said the accident happened in Pierce County. Now, is Pierce County also gonna be appropriate venue?
Yes.
Probably, right? Because of where it happened and probably what this is going to be located near in this area and so forth. We okay with that idea?
Yes.
All right. Let's keep going. So, a lot of these things that we're going to be talking about now are what we're going to term as pleading. So our complaint, for example, is a pleading. All a pleading is just our fancy term for the documents that we're going to file in the case. All right? So remember how we talked about the complaint and the summons, we need to, those are the first two to get our case going, to start our litigation. Those are examples of pleadings. Later on, when we talk about certain motions, like a summary judgment motion or a motion to dismiss, that's gonna be a type of pleading. Are we all right with that idea? All right, so most of our pleadings are gonna be on what we call pleading paper. What's pleading paper? It's a paper that says, please, please, please. What's pleading paper? What is it?
A numbered paper?
That's right. So basically, it's really kind of lovely, I think. So it has the numbers on the left-hand side. It goes from 1 to 28. Right? Some of them are different. But some are different, very little bit. Okay. All right, but that's the general idea. Are we okay with that idea?
Yes.
All right, let's keep going. So the complaint. What are the elements we have to have for our complaint? Well, we need to have the caption information, right? And so there's always going to be some sort of guidance in the form of a rule that dictates what these elements should be, what our complaint or what that particular pleading has to have. All right? So our caption is going to tell us the location of the action, right? It's going to tell us the court. It's going to have a docket file or a case number of some sort. That way we can identify it through the record, through the course of the litigation in that particular court. It's going to have the parties, right? The plaintiff, the defendant, the respondent, if we were a criminal, the state, and the defendant. It's going to have the nature of the action. This is going to kind of vary by jurisdiction. Okay? So we'll take some looks at different examples. Sometimes you'll just see it'll just say complaint. But then sometimes you'll see it'll be complaint for negligence. All right? There'll be a little bit more specificity to it, giving you an idea of the nature of the action. We okay with this idea so far? Mm-hmm. All right, so if you go and you look at this on campus, you click the hyperlink, it'll take you to the rules. That's about it. Do you want me to show it to you or we'll go with that?
Yeah.
All right. Yes, show it to you? Mm-hmm. He said, I want to see.
Yes, I do.
Show me the rule. Let's hope it works. I was just watching that movie last night.
I just watched it like a week ago.
That
So on
movie comes
Netflix
on so
now.
much though.
You had me at hello. Okay, sorry. You guys are so bad. Okay. All right. So see how when we're talking about the summons, let me make this a little bit bigger for us.
I have one quick question about
Yeah.
jurisdiction. If we are Mr. Jones or potentially FedEx themselves, I mean, those trucks can be really expensive. They've got all that equipment and stuff in it. I mean, with
But they're
that,
also
we
pretty
could
sturdy.
maybe move it up to Superior Court, huh?
So hold on a second. So that's what you're gonna get to decide
Right, right.
if you're suing them.
Okay.
Do you follow me?
Yeah.
So when you draft your complaint, you're gonna you're gonna have some notes in your information that tell me what was the basis of you selecting that particular court. So based upon the information that you guys, I'm gonna file in district court against them, right? I don't want you to worry about the fact that you're gonna get a complaint for them, okay? It's just that everybody's gonna practice drafting a complaint. Everyone's gonna practice drafting a response, okay? So when over here, you decide, hey, that FedEx truck is worth this, and then we lost this and this and this, and you do the calculation, and you give me some information that justifies you filing in Superior Court, hey, go forward, okay? It's just gonna have to make sense based upon the facts that you have in your file. All right with that?
Yeah.
All right. Okay, let's see here. So, we're gonna go down to, oh, excuse me. Come on. Turn. What were we looking for? Oh, okay, here's our summons. Here we go. So there are information in here. Cause of action, court, county, direction, notice. See the caption information, Superior Court of Washington?
Yeah,
You see that? So plaintiff, defendant, you're gonna put the parties there?
yeah.
So there's a number that stands for the case number. This says summons, but your thing is gonna say complaint. You'd have a summons too, but then you also have a complaint. And we're gonna look at some examples, okay?
All right.
All right, let's go back to our PowerPoint here. Boop. So we said we have to have the parties. Back up there somewhere. We said parties. Now we're gonna talk about what we mean when we say parties. So plaintiff, again, party bringing the suit. Right. Defendant, the party being sued. We can have multiple plaintiffs. We can have multiple defendants. I cannot speak today. All right. Can consist of individuals, partnerships, government entities, estates, etc. So these are all the people who can be our named individuals. Okay. We can identify as John or Jane Doe. Now there's some specific context in which we do so, but nonetheless we can do that. Corporations are considered as persons. We can sue corporations. Right. Corporations can also be defendants, criminal defendants. Okay. All right. Elements of the complaint continued. Real party and interest. This means the one who has the right to sue by law. All right. So, for example, I am Sarah Smith's ex-girlfriend, and I found out about her lawsuit. Can I join? But I'm so hurt. Sarah, I feel so bad for you, honey. This is so terrible.
No.
I'm gonna be a part of your lawsuit.
No.
I'm gonna sue them too, damn it. They wronged you.
No.
Really? All right. So
I'd like to join one.
There has to be some basis. We have to have an interest in the matter, okay? So we have to be the injured party or a legal representative of the party. We okay with that idea?
Yeah.
All right. Let's keep going. You guys are good. All right. So standing to sue. Kind of ready to the party interest. Party suing plaintiff must have suffered or will suffer direct causal injury, actual injury. So in other words, some relationship. Okay. Article 3, Section 2, real controversy at issue. Basically, what this means is it can't be hypothetical. All right. It can't be. Oh, maybe it was a near miss. Right. Nothing happened. You're fine. But I was almost injured. I almost could have had a heart attack and died. I was so scared. No, can't be hypothetical. Okay? Or maybe something might have happened as a result. No, okay? Is that all right? We okay with that? Capacity to sue or be sued. You gotta be appropriate age. 13-year-old, you're not gonna be able to sue. But who can sue on your behalf?
Your parents.
Parent or guardian. Legal representative. So that now they actually can have standing there. Does that make sense?
Yeah.
All right.
So when they can sue, 18?
18. Guardian ad litem, representative that may be appointed by the court for a party who lacks legal capacity or where a person needs an independent representative. We're not going to be dealing with guardian ad litem in these cases, okay?
All right, jurisdictional allegations. If we are in federal court, basically because remember, how do we get to federal court?
Diversity.
Diversity jurisdiction. Diversity jurisdiction means what?
Different states.
Parties from a different state.
Different states, and the amount of controversy exceeds?
75,000.
That's right. So we're in federal court, what we have to do is we have to allege the basis for which federal court has jurisdiction. And we do that in our complaint. Okay? In the body of the complaint, what do we say? That fool drove crazy, he was speeding, period. Is that what we say? All right, so in the body of the complaint, what we're gonna have is a statement of ultimate facts constituting the cause of action, or basically a short and plain statement of the claim. Something that's gonna show that the pleader is entitled to relief. It's our federal rules. Each claim should be set forth in a different paragraph. So if we have multiple claims of action, we're gonna have different paragraphs in which we articulate each individual claim. Don't, wait, you're not there?
No.
Did it skip? Oh darn, just when I thought we were all good.
Because the papers were down.
Did they get all confusing and wacky on you?
What page is that? You're on
Four.
page 10?
No, 4.
4, just skip
Oh,
one page, it's
it
an extra
just-
page.
Don't know where it's located.
Nope.
Complete
Page
element.
4.
Done.
Oh,
Yeah, we got
okay.
both copies.
I found it, okay.
Yeah.
Go. Sorry, we're good now.
We're all good?
Yeah.
For now.
So you got some extra copies in case, I don't know, that poor tree.
It's a positive outlook.
Recycle. I know. All right, so what do you want me to repeat, ma'am?
You said multiple complaints of something is. I couldn't hear it.
So if we have multiple causes of action, maybe we're saying, not necessarily in our case, but maybe we're saying this person was negligent. Maybe this person also intentionally inflicted emotional distress. Remember the Rothwell case?
Yeah.
Remember how she had a couple different claims of action? All we're saying is that for each claim of action, you're gonna set that forth in an individual paragraph. You're not gonna lump all that together. Is that all right? Again, and we're gonna look at an example. Are you guys okay with that idea over here? All right, we'll keep going. Allegations. You want allegations, make them simple, concise, and direct. Okay? Because we don't want to be confusing. All right? We want it to be clear. This is our claim, this is what we're alleging. Alternative and consistent allegations permissible. What does that mean? What does that mean? Because maybe I'm saying, well, it was negligent, but if it was, well, maybe I'm saying it was intentional. And if it wasn't intentional, then damn it, it was negligent. And if it wasn't this, then it was this, right? And so all this is saying is that my theories for my cause of action, they don't have to be consistent with one another. Does that make sense? All right. Prayer for relief. What do you want?
Compensation.
Okay. Pleading must set forth a prayer for relief. If defendant defaults, relief granted cannot exceed what is requested. In federal court, prayer determines the amount of controversy for jurisdictional purposes. Remember, that's why we allege it in our complaint. We got to show why are we here. Okay, hold on a second. Let's pause for a moment here. Let's manual this and let's pull up an example. Aren't you curious? Don't you want to see some beautiful complaints?
Yes.
All right. I'm trying to launch insecure content from a secure site. What the heck? Give me my document, please. Okay, so I pulled up that one. Okay, so let's look at, we're gonna take a look at a couple of different examples, okay? And I'm gonna show you different things about each example, all right? So, oh, hold on, let me make it bigger. Is that okay? All right.
what do we have here? What's this part called? What's this? What is this? This stuff right here?
Caption.
Our caption, all right? So we have the court, State of Washington, Pierce County and Superior Court, okay? Have the parties, okay? Got a case number, if it was filed, can't find them, right? Plaintiff, State of Washington, Binders attorneys, this is when Robert McKenna with the AG. Heard. Remember we talked about jurisdiction? Okay. This complaint is filed and these proceedings are instituted under the provisions of chapter so-and-so, the unfair AG is authorized, blah, blah, blah. Jurisdiction of the defendant is vested in its corporate so-and-so, blah, blah, blah. Defendant is engaged in conduct violating chapter so-and-so. What are we doing? Showing why this court has jurisdiction over this case. Defendant was engaged in business here in the state. We okay with that idea?
Yeah.
All right, then we go to venue. Okay. Venue is proper because violations alleged herein have been and are being committed in whole or in part in Pierce County, State of Washington. We all right with this? And then we go to identification of the parties, who the defendant is. We go to the facts. And then, let me skip down. Causes of action. Now, there's only one cause of action here. Cause of action, violation of RCW 1986-020. And then we have the prayer for relief. Don't worry, I'm just showing you an example. We're going to come back to these, and these are also going to be posted on, they're also already posted on Canvas. You all right? What? Doesn't it look fun? Yeah. But it's so much, isn't it fun?
Oh, it's a blast.
Really exciting. This is what you guys see. And isn't it pretty? Like, look at the indentation here. And then 6.1. Isn't it so cute?
Yeah, it is.
Okay. Whatever. Y'all, you know what?
We'll
Y'all
probably get to that
are in
point,
this
but-
class because y'all are secret legal nerds too. Okay? All right?
Not so secret about it, but
All right. Okay, so let's go back and look at our slides, and we'll come back and look at some more examples, okay?
Okay, is that what we're gonna do in this one?
Yep. So, all right.
Yeah, I know, my first class.
Okay, hold on. Let's look at another one. Let's see here. Oh, no. Going this way. Oh no, I don't want that one. Sorry guys. No, wrong, bad.
I love the sticks and it's so smart. I only have one color. Okay, paying enough attention.
You can help me.
I'm a sharer.
This one was more.
Generally, I know, but
He turned it in.
it does right.
All right. Right horizons. Now I like this packet for a number of different reasons. I like this packet because you get to see a number of different examples of certain types of pleadings. Okay. So this one we start off with this we start off with the summons, right? So the caption information still the parties, right, to the state of so-and-so, state of Washington too. We got the parties right here, okay? Let's see, all the information about, you have to respond, if not default judgment, blah, 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 got 14 days. All right, all of that information. Keep going. Then we have our complaint. So this one says complaint for damages, right? The last one just said complaint. Okay. Someone say complaint for negligence, right? Okay. Comes now plaintiff, blah, 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 individually and on behalf of blah, 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 and alleges as follows. You guys are gonna need to make up your firm name. Y'all gonna need to make up your firm name. Okay. Make up your attorney's name, Okay. Incorporation by this reference, each paragraph contained herein is incorporated as support for each paragraph which follows. This is very interesting. All this means that what they're saying is that everything that's going to come below is all related to what we're alleging. And so we're just going to incorporate it. All right, plaintiffs, identification of the parties, defendant, venue and jurisdiction.
So you see how you're gonna see some variety. That's why I give you different examples, because you're gonna see that they might be structured a little bit different. See how the last one, you have 1.1, 1.2? This one just goes straight down. You with me? I'm gonna ask that you do 1.1, 1.2, 2.3. I think that's a cleaner. Okay? That's just my preference. I like that way better. Okay? But nonetheless, either way, I'm gonna show you different examples. That way you're not thrown off. And you can go through and you can look at different examples, so you can still pull out the meat and you recognize the substance of what's required. We got parties, we got venue and jurisdiction, we got some causes, we got some facts, we have some causes of action. You with me? So you recognize the substance of being a complaint, even if it looks a little bit different. Okay? Factual summary. First cause of action. See, this is a little bit. Now this, like this. It's a little bit different. In the first one, we only had one cause of action, right? But this one we have multiple. And I like how they go first cause of action, negligence. Second cause of action, RCW so-and-so. Gotcha. You with me? So I'm going to show you different examples, but not but the one example doesn't stand for every single principle that I like. Does that make sense? Okay. So you're going to take the best pieces of each example. Gotcha. Okay? All right. Prayer for relief. Wherefore plaintiff prays for judgment as follows. All general and special damages, prejudgment interest, attorney's fees. You always see this, any other damages available under law. And further relief as the court deems just and equitable. Huh?
Any other damages available?
Any other thing possible. Because we're not gonna limit ourselves. Okay, there might be some damages I ain't came up with yet, but we just filed it. We're gonna do some discovery, which we're gonna talk about later. Maybe we'll find out some more stuff I can claim. All right? You okay with that? Okay. All right.
So the prayer for relief, that's just saying what you want.
That's
You
right.
know,
Prayer for
to get out
relief.
of this.
That's just our old classic language. Prayer for relief. What do you pray for? What kind of relief are you
Money.
praying the court's gonna give you?
Okay.
Okay?
Money.
Make your money. Yeah.
All right. Uh-oh. Okay, skip this out. Let me go to where we were. Okay, here we go. So prayer for relief, remedies. So first we have the idea of compensatory damages. What's compensatory mean? That's right, compensate, okay? They're general damages. These are damages that are a direct and natural cause, right? So the car, damages to the car, compensatory damages, that's direct. Medical bills, that's direct, right? Let's see. Then we have the idea of punitive damages. Punitive damages are damages above and beyond compensatory damages. No, these are damages, because I can prove that. I can bring a doctor and an expert to say that I've been damaged. I'm gonna need some serious therapy. That's gonna cost me a bill. You with me?
So punitive more like.
Punitive damages means exactly what it says, punitive. We want to send a message, and the deepest way to send a message to a company or a person, at least as we think in the U.S., is to hit them in the pockets, right? Is that okay? All right. Now, what we should know about Washington State, however, is, anybody know?
Washington doesn't do punitive damages.
Washington only does punitive damages where the statute actually permits it. Okay? So absent a statute expressly authorizing punitive damages, you're not going to be entitled to this. Okay? Alrighty. Other types of prayer for release, a prohibitory injunction. Order that informs the defendant to refrain from doing something. Stop from, let's see. Maybe it's a suit about using a person's name or image. So part of it is you want the damages, you want any sort of money that they may have made off your name without your permission, but you also want them to stop. Okay? Mandatory injunction. Maybe you want to make the defendant actually do something. All right. Business performance. This kind of related a little bit, but basically, breach of contract. The party has failed to fulfill particular provision that they're supposed to do under the contract, or maybe they didn't do something. Same theory, you're asking the court to make them do something. All right, continuing on with the complaint and the elements. We have to have subscription. Why we don't just say signature? I'm just saying, right? Oh, but so,
We want the layperson to get confused.
but I want you to know it both ways, all right? So if you see that funky language about subscription, just say, don't school me, signature. Okay. All right. Complaint must be signed by the attorney, or can we proceed pro se in the civil arena? Yes, we can. So if you're proceeding pro se, then that pro se person has to sign those documents, okay? Federal court, the signature certifies, to the best of the attorney's knowledge, formed after reasonable inquiry. Remember, that's how we do that pre-filing workup. We do a little bit of information, some digging, make sure we actually file in a case with merit. Then after we do that, the evidentiary contents have evidentiary support and are likely to have support after discovery. So based on what I know right now, I think there's a basis for me to file this claim. Oh, I think there's a basis, and I think I'll have even more of a basis after I get the case filed and maybe to go through some discovery and get additional evidence and information. Okay? All right, claims or defenses are warranted by existing law or a good faith argument for change in existing law. So I'm also warranting that. And the complaint is not presented for any improper purpose. This is not a frivolous or malicious suit. It's brought in good faith. Where are we at on time? 10:30, we're doing good. Y'all okay? All right. So I want to talk to you about a different concept. We're also ready to filing, but I gotta give you some background, okay? Bless you. So I'm gonna talk to you about this idea of joinder, then I'm gonna talk to you first about the background. So, splitting of claims. So I'm gonna read it to you and then I'm gonna explain it, okay? So a pleader cannot split a single claim or cause of action into several parts and file separate suits on each of them.
You did just have an example or something.
Wait, no, we just talked about it, Rockwell, right? So she can't say, okay, all right, this part of my case is negligence, all right. I'm gonna file this case right here over this court for negligence. And then I'm gonna go right here next door, I'm gonna file this case over here for the intentional infliction of the emotional distress. You with me?
Yes.
You can't split the claims like that.
Why
It's
can't you
all
just
part of one case, so it makes sense to litigate the case one action.
Yeah.
That make sense?
Yeah.
All right.
Unless you're suing.
So if suit is brought on only one part of the claim, the concept of res judicata may bar later suits on the omitted claims. So the idea of res judicata is that if it all belongs together, this all belongs together. It operates as a unit, right? Then you bring it all together. But if you rip it out and slice it up, then what we're gonna say is under the concept of res judicata, you know what, that's too bad. We decided this case, you had an opportunity to bring in those other things, they were immediately and directly relevant, you didn't do that, too bad. With me? Yeah, all right. Okay. So, why have a joinder of claims? Kind of following from that discussion about the splitting of claims. Well, joint related claims. Danger of res judicata. You don't want a court to say, wait a minute, we've already decided this case, right? We're also going to reduce litigation, okay? We're already file litigation crazy, okay? So we don't want to clog up our court systems. The other thing is that we protect the parties by including all the relevant parties in one suit, all right? Particularly where if it arises out of the same set of facts, it just makes sense. I got all the relevant parties, we're all gonna go to court and hash this out, okay? So, bottom line, joinders are actually encouraged. And the rules are interpreted very broadly to allow a joinder where the facts hint at such as appropriate. Are we okay with that idea? All right. Okay. Keep it simple. Bottom line, you're simply talking about bringing in additional parties and when that may be required or permissive. So don't let the idea of a joinder confuse you, okay? So if you get stuck, come back to this slide. Bottom line, all we're talking about is who else does it make sense to bring in because they relate to the same set of facts. What are the causes of action make sense because it arises out of the same situation, okay? All right. Our joinder rules can be found under Rule 19 and CR 19. I think the extent to which we just covered them are sufficient, but like I said, there's a hyperlink here if you want to go and peruse that. So I told you at the beginning, we'll do our state level rule, but then we'll also compare to our federal counterpart. So under the federal rule, a joinder is required where we have a person who is subject to service, meaning they are party, they need to be served the case. When necessary to grant complete relief to an existing party. So maybe, for example, maybe you filed your cause of action against defendant A, right? Just A, right? But if there's another person over here that should also be involved, okay? So maybe we're gonna say, wait a minute, the idea of this joinder should, sort of suggests this person also has some sort of relationship to this case. Or maybe, does that make sense? Yeah. And we'll talk about how that can get a little bit complicated in terms of end leaders and all that. But for right now, it's just the idea that when it makes sense, okay? Let's see. When not doing so will cause an existing party to bear unjust, multiple, or inconsistent obligations. So, like I said, this other person, if I'm being sued, right, and a joinder is appropriate, it makes sense to bring in this other person, particularly if this person also is going to have some liability or responsibility. Okay? All right. Permissive voluntary joinder. This is more like civil procedure too, but I'm going to tell you because it's very much related. Parties may be allowed to join multiple parties, and defendants when claims against the potential parties arise out of the same occurrence, seen from any common questions of law and fact. So same thing. So we might not have the same interest, right? But there's something about the same set of facts to which we're all related. So again, it just makes sense. Interesting joinder case. Let's take a look at this case. In EMC Corporation. I hope that this link works. Say okay. All right, so let's take a look at the facts here. So petitioners are 8 of 18 companies named as a defendant in a single complaint. You got that? Okay. So there are 8 of 18 companies and they're named as a defendant in one complaint. Okay. Oasis asserted the method claims from 4 patients. Specifically, the patient claims methods for allowing home computer users to remotely connect to an online service system for purposes of external data and program storage and additional processing capacities. The defendants in this case are all alleged to offer services that provide online backup and storage for home or business computer users. So kind of like that cloud stuff? Yeah. Okay. Am I okay with that idea? Okay. All right, so let's see the complaint. In particular, petitioners are alleged to offer online backup and storage through websites such as whatever. Okay, let's keep going. Petitioners sought orders to sever. What does sever mean? Separate. That's right. Break apart. Yeah. To sever and transfer the claims against them to more appropriate venues, arguing that because there is no concert of action, the claims against them did not arise out of the same transaction or occurrence as required by Rule 20. So you get what they're saying? Okay, they want to break it up. It doesn't arise out of the same transaction. Oasis argued that although the asserted patents cover a broad range of technologies, the accused infringement in this case is limited to online backup/storage services, and that each defendant offers a similar commercial online backup storage service. So they're saying they kind of all operate in the same way. Okay.
All right, this?
Yeah.
All right, let's go down. The magistrate judge, so this is what happened below, found nothing improper about maintaining these claims in one action. All right. For claims validity, claim construction, the scope of the 4 patents or questions common to all defendants. Remember, that's what we're looking at. What's the commonality, right? Moreover, the claims arose out of the same transaction, occurrence, or series of transactions or occurrences, according to the magistrate judge, because the accused services were not dramatically different. So, remember, the principle is if it arises out of the same sort of circumstances, it makes sense to join them. That's what they want to do. All right, so these are the findings of the magistrate judge. Finally, the magistrate judge stated that granting defendant's motion to sever and transfer would be the division of a single action into 7 different lawsuits scattered all over the country. Okay? The district court adopted these findings and conclusions. So you see all the different levels, right? Okay. Let's keep going. Sorry, I'm just going to get down to the part that's most relevant to us in terms of whether or not they agree. I see, and this is so lovely, all this stuff, right?
Yeah.
They're giving us also the application, they're analogizing other cases, blah, 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 blah. Okay. We turn to the issue of severance. But don't you love how they give you nice transitions? Right? It's a nice little thing, okay? All right, let's keep going. We're going to skip over the analysis. When considering a motion to sever, courts have to look to Rule 20 for guidance. Defendants may be joined in a single action only if the 2 independent requirements are satisfied. The claims against them must be asserted with respect to or arising out of the same transaction, occurrence, or series of transactions and occurrences. There must be a question of law or fact in common to all defendants. Makes sense, right? Okay. Rule 20 clearly contemplates joinder of claims arising from a series of transactions. A single transaction is not required. It is clear that where defendants are alleged to be jointly liable, where they are alleged to be jointly liable, remember the idea of you suing defendant A, but hey, defendant B, he should be in too, because, you know, hey, we're going to share this stuff, but we're going down, you going down, jointly liable. So it's appropriate they be joined under Rule 20. If the transaction or occurrence test is satisfied. Cases make equally clear that the fact that the defendants are independent actors. So again, we didn't operate into who's together, but nonetheless, same transaction, same issue, that doesn't preclude the joinder. So that's the court's analysis. Okay? You get an idea of that? All right. That's a pretty dry case, but it just makes the point of how the court's analysis, do the analysis of whether or not a joinder is appropriate. Okay. How are we doing on time?
10 minutes.
We have 10 minutes. 8 minutes. 8 minutes. Okay, fine. This 8 minutes. Look at it. Okay, we don't have too much more to go. We don't have too much to go.
Thank you. Yeah.
All right, so we're going to skip Van Pleader. We'll come back to that. It's a little more complicated. We'll talk about class actions. Suit filed against an entire class, members of which are too many for a simple joinder. Or the idea of joinder is like, hey, we should bring all these people in. They have some relationship, right? But we can reach a point where it's like, whoa, this is a lot of people. Maybe this should be a class action. Rule 23 applies, and here are the elements. We have to meet these elements in order to be able to qualify as a class action. Just because you got a whole bunch of people doesn't necessarily mean you're automatically going to be qualified as a class action. You got to meet this test. All right? Test is too many people, too many members for joinder. We got common questions of law and fact. Claims of representative are typical of those of the class. So the party who's bringing the action, the class action as a representative, that my claims are representative of the people who I'm saying should be a part of this action. Okay?
The representative would protect the interests of the class. I'm here not just for me, but I'm here on behalf of all these individuals. So there's a commonality, and my part in this is to protect the interests of us as a collective group. Separate actions will be likely to bring inconsistent results. If you split us up, they can sue over here, they can sue over there, they can sue over here, and we all might get different things, okay? Separate transaction may hinder or preclude action of other members of the class. Maybe that's also gonna hold each other up. Maybe this court's gonna say, well, hey, there's a similar action pending over in that court, let's just wait and see what they do. You know what this court's gonna do? They're gonna say, hey, there's a similar action over here, let's just wait and see what they do. Can you imagine? All right. First party has acted or failed to act in a manner applicable to the entire class. The conduct of the party that we're suing, their conduct is applicable to everybody. That's what we're here, commonality. Class action is superior action under the circumstances. Under the circumstances, these foregoing, this just makes sense, okay?
I'm sorry, did you already mention what's too many for single joiner? How many?
I think it's gonna depend upon I think it's gonna vary. I think it's gonna vary upon the facts and circumstances. Let's see. And the other thing that complicates the case is just because you have a whole bunch of people, still doesn't mean that you're gonna qualify as a class action. Your classic example of that, and I think we'll end on this note, is the Walmart case. For Wednesday's class, that's your homework. For Wednesday's class, I want you to find the Walmart action, okay? Go to Google, Walmart class action. I'm not sending you out on a false switch, I'm not here.
Turn it up and bring it in.
So you don't have to print it out, but just find it, read it, come prepared to talk about it. And we'll end there. You guys did really good. Sorry it was so long. I'll see you on Wednesday.
Walmart?
There was issues with the